Good afternoon, everyone. My name is Katie Sabota-Kindle. I'm an attorney at Community Legal Services. Welcome to our webinar. This webinar is given as part of our National Record Clearing Project here at Community Legal Services. And here in this webinar, we're going to be talking about recent victories in record clearing in Georgia, Michigan, and North Carolina. We have 6 folks from those states here to talk to us about how they overcame great obstacles in their states, and we want to know, how did they do it? So they're going to be telling us today. We have a very illustrious panel here of 6 people. I could talk for the full hour about these 6 people, and because we do not have an hour to talk about them, we have included their biographies in a handout that we have included for you guys. I really do want you to read that because this is an impressive group of people, but I'm just going to go through them very, very quickly. One second. We have on Team Georgia, we have Brenda Smeeton. She is the legal director of the Georgia Justice Project. And we have Marilynn Winn. She is the executive director of Women on the Rise. On Team North Carolina, we have Whitley Carpenter. She's a staff attorney from Forward Justice in North Carolina. And we have Daniel Bowes, who's the director of the Fair Chance Criminal Justice Project in the North Carolina Justice Center. And then on Team Michigan, we have Hakim Crampton, who's the Michigan statewide organizer for JustLeadershipUSA. And we have John Cooper, who's the executive director of Safe and Just Michigan. And just a few things before we get started on the actual content here. We have handouts for you. One of them I've already mentioned, which is goes into the biographies of our 6 presenters. We also have a handout for each state. That's going to include things like more details about what the laws actually do in each of those states. So I encourage you to read those. And we also have a PDF version of the PowerPoint slides. So we will be sending those out in an email as well. This webinar is going to be recorded, so we will also send out the link to that. We are also going to be doing a Q&A at the end of the presentation. Please just write in the questions that you have into the question panel here whenever they occur to you, and we will ask those questions at the end. So without further ado, we have a lot to talk about in a very short period of time. So we're just going to get started talking about Georgia. So Brenda, if you want to get us going.
Sure. Thank you, Katie, and thanks to CLS and Sharon for inviting us to participate. I'm so excited to have something positive to say about Georgia. We've been working on this for a while. So the law that we got passed, it was SB 288, and so it went into effect this past January 1st. And it's a modest reform compared to some of the other states you're probably going to hear about, but it's huge for Georgia. And like I said, something that we've been working for several years. So up until this January, the only things that you could expunge from your record in Georgia, which we don't use the word expungement, it's a 2-step process that we call restriction and sealing. But the only things that you could get off of your record were most non-convictions, not even all non-convictions, and certain misdemeanors that an individual was convicted of before they turned 21. So not even that they were arrested for before they turned 21, but the conviction actually had to occur before they turned 21. So it was extremely limited. So under SB 288, what it does is it allows for an individual to petition the court where they were sentenced to restrict and seal up to 2 misdemeanor convictions, and that is incidents, not charges. So according to the data we have, this could potentially impact up to 1.5 million people in Georgia that have only 1 or 2 misdemeanor convictions on their record. We were able to make a couple of other improvements, though there's still some work to do. For what we had before for youthful offender, you had to wait 5 years after your sentence. We got that reduced to 4 years, and it used to say that you couldn't have any arrests in that 5-year period, and now it says that you can't have any convictions in the waiting period. It is a petition-based process. For felonies, we were pretty deflated on felonies. It had been stripped out of the bills that we were working on, and then at the last minute, we worked with our sponsor to introduce an amendment on the floor of the state Senate to include a process for folks to petition to restrict and seal their felony conviction or convictions if they had received a pardon, which is a process in Georgia that happens through the State Board of Pardons and Paroles. And about 500 people a year in Georgia get a pardon. So you can get a pardon for any offense, any felony offense. The way that SB 288 is written, if it's a serious violent felony or a serious sex offense, then you wouldn't then be able to petition the court to expunge it, but all other felony convictions, and there's not a limit on the number there. And then one last thing before the next slide that I just wanted to mention is another major reform that passed in Georgia, not our focus for today, is SB 435, which provides a really aggressive and comprehensive way for people who are survivors of human trafficking to be able to vacate their convictions and seal them. So that's something else that we've been working on. But the other, in the next slide, it talks about what SB 288 does for employers. So one of the things that really turned the tide for us this last year is partnering with the Metro Atlanta Chamber of Commerce to try to get something across the finish line. And they worked on some language with us, going back to their members and constituents about what they would like to see in the expungement bill. And of course, you know, in addition to limiting what employers can see on a background through SB 288, because our restriction and sealing process does seal the court record, it provides significant liability protection for employers. So evidence of somebody's criminal history is not admissible in a civil case if the criminal history information is not relevant. So, you know, of course, something for the attorneys to argue about there, but if it's not relevant, or it has been restricted and sealed, or it has been pardoned, or it concerns an arrest that did not lead to a conviction, then it can't be used in a civil suit against the employer at all. And that was at the request of the employers that we were working with. So I'm going to turn it over to Marilynn to talk for a few minutes about how we got there and how the organizing work that she started years ago that built up to this.
Good afternoon, and thank you again for having me on this panel, and I'm very excited to be here. And how I got started on this panel is I am formerly incarcerated, and I knew that if I didn't start somewhere to start trying to change the system, I realized that I would spend the rest of my life in prison and die there, and that wasn't what I wanted to do. When I had my last arrest and I was offered to go to prison for the 7th time, I was sentenced to go to prison for the 8th time actually. I had a dialogue with the judge and he understood where I was coming from. All I needed was a job and couldn't get that job. I had 18 jobs, but I was terminated from all 18 because I lied to get them. But when I told the truth to get them, I didn't get them. So and when he listened, I started trying to figure out, so what do I need to do next? How do I take care of myself? So I just started calling and asking people about the box on the applications. How do you remove this box? So so I could, at this time I was saying, so I could get through to an employer. But I had no idea that it was so many Black women and Black and brown people that were being denied employment because of a background, no matter what that background was. If you said you've been arrested or convicted, it didn't matter. You did not get a job in Georgia. And if you got one, it was not a paying job. It was a minimum wage job at this time of $6.35. So I did some work with the organization. I volunteered with the organization doing some minimum wage work. And I happened to walk in their office and I saw on their wall their mission. I didn't know anything about organizing or none of this kind of work. But when I looked on the wall, it looked like a piece of not newspaper, but brown paper bag to me. But I later learned that it was butcher block paper. And it said, "We achieve economic justice for low-income women that are directly impacted by employment discrimination." I said, well, this is me. I said, so how do I tell? And it was, at this time, it was all white women here. So I'm going, so how do I tell these white women that this is me? How do I get across to them so I could get some support with employment? but I didn't tell them. I just kept volunteering, and I became co-chair of the board of directors. And finally, they got someone, an organizer from Ohio came in, and she was a Black girl. So I started talking to her, and she said, well, I have family members that are been incarcerated, and they actually get jobs. I said, so how do they get jobs? She said, well, in Ohio, they don't have a box. They removed the box in Ohio. So then I started reaching out to Georgia Justice Project. I reached out to an organization in North Carolina. I started reaching out to people. And then I went back to the same organization and said, I want to start a campaign. And they said, well, you can't start a campaign. I said, but your mission said this, and your mission also says that the members choose the campaigns you work on. I said, so I am formerly incarcerated, and I need to get me a job where I can take care of myself. And anyway, that's where it started at. So from there, I was able to start that campaign with that organization. We made history with being Atlanta, the city of Atlanta, actually being the first entity to ban a box that supported formerly incarcerated people into employment. So from there, I learned that so many other barriers that we had, and what got me into this work. So one thing led to another. And during this work, we did ban the box. Then we also did, the city of Atlanta had 81 ordinances on their books that we were able to get removed. We also did, there was a area in Atlanta that was trying to banish sex workers from the city of Atlanta if they was caught doing sex work. We hopped on that, and we were able to turn that around, and actually that campaign turned into a 501c3 organization today that is supported by the city of Atlanta and by Fulton County. And behind that, we did repealing of marijuana reclassification, where in Atlanta, people were, Black young men, college students get arrested for less than an ounce of marijuana or roach. They actually went to jail, prison for at least a year, and and fines of thousands of dollars. We was able to get that legislation reclassified to a non-arrestable offense, and a maximum fine of $75. Then in collaboration with other organizations, we worked on bail reform, and we were able to get that, which led to the work that I do today, and that is closing the Atlanta City Detention Center. So why this was important to me and why I support SB 288, I always talked about a record redemption, which, like credit, your after 7 years, your credit automatically restores itself. And I was talking to different people about that. And so when I heard the Georgia Justice Project were doing something called record restriction, similar to that, and we've been partners for years, and I just hopped on it, and I was really surprised when it did, even this part passed, because when I was talking about it and they were talking about this record restriction, and well, we don't think they're going to do, I said, I got plenty of faith. I believe that time brings a change, and it's true, time does bring a change. And what that SB 288 does for formerly incarcerated people, it relieves them of a life sentence of barriers, a life sentence of barriers. I went through the system 41 years, in and out of the system for 41 years, just because I needed a job, and barriers like a record held me back. And it don't matter what it's for. So I support it, looking forward to doing more work with it and getting to that record redemption. So after 10 years, everything you got just drop off the record. And that's what I'm looking for. So I'll pass this back to Brenda, and thank y'all again.
Thank you, Marilynn. So just for a couple of minutes, so I think we were able to get SB 288 across the finish line because of the many years of organizing by people like Marilynn, and the relationships that we had built in the community. Just a couple of points about what I think finally moved us this past year, because we had bills we worked on in 2018 and 19 that didn't even make it out of committee. So we switched our focus up a bit. We were having a lot of pushback from prosecutors in particular. So we put together the Second Chance for Georgia campaign, and we had over 74 organizations that endorsed the campaign, and it was really easy because of all the work that Marilynn and other folks had done educating about this, like, we didn't have to even hardly put the word out. Folks were just coming to us saying, how can I be a part of this? Congregations and different kinds of organizations all across the political spectrum. Last thing I really want to mention is, I think getting the Chamber of Commerce involved this year was essential. We had been at Georgia Justice Project, we'd been doing events with employers for probably about the last 6 or 7 years. And these were sort of roundtable events that we would do maybe once or twice a year that were more conversational, not presenting information about criminal records and the research that's out there about hiring people with criminal records, but really listening to what their concerns were and how we might address some of their concerns through legislative reform. So in 2019, the Chamber came on board and agreed to work with us. And even though the employers that we had been meeting with had been supportive and understood our perspective, they weren't really sort of out there willing to put themselves out there publicly and support what we were doing. But I think with the endorsement of the Chamber and conversations kind of happening through them, that changed. I also think so in Georgia, it was a weird session last year, like a lot of years. We got suspended. The session was suspended in March and then came back in May. And you're probably aware, last year in Georgia, in February, Ahmaud Arbery was killed. The video wasn't made. He was murdered. The video wasn't made public until May. Also in early June, Richard Brooks was murdered by the police. So there was a lot going on in our communities, as there was across the country. And I think that really had an impact on the willingness of the Georgia-based employers, companies that wound up writing a letter of support for us, like Coca-Cola and Home Depot, McKinney's, the companies that I've listed here, who may have been reluctant to sort of speak out and make the connections between what was going on in the community and the need for expungement. And they said, we're ready to be a part of this, and certainly having their letters of support and their endorsement was essential. So I think that was a key factor.
All right, thank you so much, Brenda and Marilynn. Now we're going to talk about Michigan a little bit. So John, if you want to get us started.
Sure, thanks very much. So the Michigan Clean Slate campaign launched about 2 years ago, and we passed it was a 7-bill package. There's 2 components to it. The first one was to expand eligibility for our court petition process. Historically, you could get 1 conviction sealed in Michigan if you had nothing else on your record, and more recently they expanded that to 2 misdemeanors, but if you had 3 misdemeanors, you couldn't apply to get a felony sealed, or 2 misdemeanors. So it was a really inadequate process. Traffic offenses were not eligible, and those are 50% of all our criminal cases. So, the eligibility expansion was really the culmination of a number of years of work just on the limitations around record sealing in Michigan. So among other things, the eligibility expansion package increased the conviction limits to 3 felonies and an unlimited number of misdemeanors with some limitations on repeat convictions. It expanded eligibility to most traffic offenses, marijuana possession or use misdemeanors, which is a large chunk of the cases we have. We just legalized marijuana in 2018, and there's about 250,000 misdemeanor convictions out there. And then there was some other reforms to reduce the waiting period from 5 years to 3 for misdemeanors. They're allowing transactional counting of multiple convictions received out of a single criminal transaction. So those are all really good and important reforms, but the really, I think, major advancement that happened in the Michigan campaign was automatic expungement. And we were the first state to do felonies. Our automatic expungement permits many felonies in Michigan. The assaultive felonies were carved out, and there are some financial crimes that were carved out, but a broad range of felonies are eligible for this. It's up to 2 after 10 years, and can do 4 misdemeanors if they're up to a year punishment, and there's an unlimited number of misdemeanors eligible if they're less than 3 days misdemeanors. So there are a number of ways in which this was a historic reform. I mean, we're the first state to do felonies, but also there's no limitations on eligibility for unpaid criminal justice debt, which is a big problem. You know, we're hoping to expand this even further in years to come.
Absolutely. Thanks, John, for that. And as we continued to build our campaign here in Michigan, similar to Marilyn's story, a person like myself, having been directly impacted, having spent 15 years of my life inside the correctional system, and been dealing with the system off and on as a juvenile, I was very, very passionate about getting actively involved in this campaign and seeing this campaign actually make it to the finish line and seeing a bill get signed into law. And of course, as a person directly impacted, I and many other people like me would have liked and have loved to see this bill as expansive as possible, to include as much as we could. But in order to really push and drive this campaign here in the state of Michigan, we felt there was a strong urgency to get our community involved. In order to get our community involved, we didn't want them to just get involved to become aware of what was happening at the legislative process, what was happening in our state's capital, the conversations that were happening behind closed doors. We didn't want them to just become aware of that. We wanted them to actually get involved with that conversation. So we were fortunate to have someone like John himself who had a connection with our legislative that allowed us to then get access to pre-drafts of the bill, and then take those drafts of the bill back to our communities. We traveled the state of Michigan, circumferred the entire state, 9 major cities. We went from the east of our state to the west of our state and everything in between. And we held very, very intense community listening sessions. These listening sessions were not only driven by the proposed draft bill, but they were driven by the larger conversation about how do we, as directly impacted people, directly impacted families, and constituents of our legislators, how do we get involved with that conversation to help really shift the narrative and drive it? And so those are the kind of questions that we asked at these listening sessions. We specifically asked the questions that would be in the bill, because the bill would ask such questions like, who would qualify? Who should qualify? When should a person qualify? And there were different determining factors. We talked about Clean Slate, which is the automation process. And then there's the process in which a person could file through the application process, our long standard history process. We wanted to really help shape both of those conversations. So we asked questions from our citizens, from our community, from the constituency. What does this look like for you? Who should be included? How should it be included? When should it be included? These are the type of questions that we then took back to our legislators and said, hey, we've gone into your districts. We've sat with your constituents. And oftentimes at these listening sessions, we had many stakeholders there. County prosecutors were there. State public defenders were there. State city council members were there. Mayors were there of cities. A huge array of stakeholders were there. The answers that we got allowed us to go back to our legislators and say, hey, this is what your constituents are saying about this proposed bill draft. How do we then incorporate their voices into this? In order to incorporate their voices into this, we furthered the process by not only having those community listening sessions, but we educated our community about the process of how to actually lend your voice to the legislative process. So we created storytelling workshops and opportunities for our constituency, for our people to actually get involved because they were directly impacted. So these storytelling workshops, after we had visited our 9 cities, we went back and trained them and prepped them to prepare to actually meet with the legislator, to share their story, their direct story, to share Marilyn's story, right, with the legislator. See, Marilyn got a chance in Georgia to share her story with the judge, which was powerful for her, I'm sure. This process, while we were seeking to get laws written and changed, we knew we had to take that same story to a legislator and convince them. So we developed these massive storytelling workshops. We went across the state, trained people and prepped them and took them back to our legislators and had them share their stories. And it really helped drive home our legislation and really helped craft what would appear in the media as our legislation packages were being pushed through the House, through the Senate. The media was there at every step of the way. And we wanted to make sure that as the media was writing about our campaign, that the voices of directly impacted people was also inside those media voices, so that the community could really hear both sides of the story. And it was just a great campaign. I was very fortunate to be a part of this campaign.
Yeah, and the media coverage of our campaign was terrific, and that is a big credit to Hakim and you know, the other organizers that were working on the ground. I mean, me going to the legislature and saying this is important isn't going to generate media coverage, right? We need compelling storytellers to do that, and that was a major driver of our campaign. But you know, as Hakim said, you know, like I occupy more of an inside lane in advocacy. But we need both outside and inside advocates to work together to navigate the process. And, you know, a couple things we thought were really important in the context of this campaign were making sure we have legislative champions and champions within the administration who can overcome resistance from opponents, particularly opponents within the bureaucracy. So, for example, our state police runs our criminal history database. They had some misgivings about the policy changes we were proposing. And, you know, so we worked with champions inside the administration to you know, work through those concerns. We had, you know, months of meetings about implementation, technical feasibility, cost. And those are all things that can be hard to have an outside group come in and really work through with administration. So you need someone on the inside to help you do that. And Code for America actually was very helpful with that as well. You know, we also needed legislative champions to navigate the legislative resistance. You know, prosecutors, law enforcement were resistant initially to the ideas that we were proposing. But we had really strong legislative champions. They wanted to make Michigan a national leader in record clearing. They really thought it was important that felonies be covered by the automatic expungement. And they helped navigate, you know, resistance around unpaid criminal justice debt, out-of-state background checks, which are a requirement of our petition process currently. And, you know, it's a testament to the hard work of legislative champions in many ways. And, you know, I think it's really important to find the advocate within the legislature who can really drive your legislation forward, because there's going to be conversations that person can have that you can't. This was most of them supportive of the bill, automatic expungement. The state chamber.
John, you're kind of going in and out.
I'm sorry. Hear me now?
Yes, I think so.
Business is really important. Is the groups that are most concerned with record sealing, because in Michigan we have a public record that's sealed, but law enforcement maintains a non-public one.
I'm sorry, John, you're still going in and out, for me at least. So let me just go to the next slide, if that's okay. Sorry, John. All right, so without further ado, hopefully we can go back and hear what John had to say. We're going to talk about North Carolina a little bit. Thank you again to John and Hakim. So Whitley, if you could get us started talking about the Second Chance Act.
Yes, so good afternoon, everyone. I will just try to keep this as short as possible to talk about just the provisions in the Second Chance Act that the major changes. And the first one is really the ability for district attorneys to initiate relief, which really opens the door for mass relief opportunities. So basically on any of the expungements in North Carolina where there is no discretion for a judge to say no, for example, with dismissed charges, and for what we call raise the age expungements, which I'll get into in a second, there's a DA initiated relief where they can look at the data set and just do mass expungement petitions to get rid of so many of these records in the state. The second part is expanded eligibility. And so we are now able to expunge an unlimited number of misdemeanors after 7 years, after a 7-year waiting period. Additionally, I mentioned raise the age. North Carolina was one of the last states in the country to still treat 16 and 17-year-olds like adults in every criminal courtroom that they were to go in, and that recently changed such that 16 and 17-year-olds are now treated as children in juvenile court that can be transferred to adult court. But the idea with this raise the age provision in our Second Chance Act was there are kids now that did not get the benefit of the Second Chance Act. So if you're 16 or 17 years old right now, you commit whatever crime, you are looked at as a child. But a couple of years ago, that wasn't the case. So this provision of the act allows folks who did not fall into that raise the age window to be able to expunge those records that they received as adults before raise the age went into effect. And then the last part is about dismissed charges. So prior to the Second Chance Act, you were banned from expunging a dismissed charge if you also had a felony conviction on your record. And so that removed that provision so that all dismissed charges are eligible for expungement. The last part, and it's what John was just talking about, is great, is the automation portion. Unfortunately, we haven't gotten the felony convictions yet. We'll get there, but this is really related to dismissed charges. And so as of December 1st of 2020, you can automatically get dismissed charges expunged where all of the charges in one case have been dismissed. So when it comes to a plea agreement, then things kind of change a bit. You can still petition for relief, but when all charges within one case have been dismissed by the court, that will automatically be expunged. No further action needs to be taken. And what we were seeing was that there were so many people across the state of North Carolina that were eligible for expungement, but just did not file these expungement petitions. So it wasn't only a question of eligibility, but also accessibility. And so this automation component really allows access to people who may not know they can get their record expunged, may not know that dismissed charges are on their records, may not have the resources to hire an attorney or the resources to file these petitions or know how to do that on their own. So we are continuing to push for expanded eligibility and accessibility of these expungements. I hope that was quick enough. I'm going to pass it to Daniel now to kind of talk about how we got here and get us to where we are right now.
Yeah, that was quick. You got me pumped up, Whitley. Good to be with y'all today. I'll just provide a little bit of context about sort of where we were coming from and sort of why we engaged in the strategies we did. Similar to what Brenda and Marilynn were talking about, when we started our expunction work in 2010, there was virtually no ability to get anything expunged. It was basically one dismissed charge, and if you used it, you can never do that again. And so half the time we were telling people, this may not be a serious enough charge for you to use your one-time expunction on this. And but gradually over time, we basically had an expunction bill pass every year. But you introduced it, and the first time it was a first-time nonviolent misdemeanor or felony after 15 years. And so we started lowering it from there. And so, but the good part of that was we did have, a seasoned coalition of people, lobbyists and others, who were at the legislature a lot, but also the legislator themselves became very aware of collateral consequences. Also, when we could talk about, okay, you passed these, 6 expunction bills over the last 6 years, and nobody's accessing that relief because of the second chance gap. And so that's why we need to automate. We also have a very outdated court system, though it is unified in some ways and does have an overall sort of technology system. There's huge deference given to local actors, especially clerks of court, and how they do the record keeping. And also, I'm sure this is the way it is in every place, that every sort of professional stakeholder in the courts has their own special interest and sort of is very, largely deferred to. And so that's been a issue for a long time, and especially with the North Carolina Conference of District Attorneys, which is treated as a sort of complete gatekeeper, along with the Sheriff's Association, for any sort of criminal justice reform. Now, one of the exciting things that we saw through this campaign was that that sort of gatekeeper status was still alive and well, but it wasn't as absolute as it had been in the past. And then again, there had been this sort of growth in over 10 years where, every year we have a Second Chance Lobby Day where we have impacted people come to the legislature and talk about different issues. And a lot of that had been focused on expunction relief. Next slide, please. And so, we really relied on the past sort of sponsors of the expunction bills, and we happen to have, I think the Republican Party is well in control in North Carolina, but has been dedicated to expanding expunction relief. And so we went back to those same actors, which was the president of the Senate, Phil Berger, and then the two co-chairs of Judiciary, and especially Danny Britt, who was a criminal defense attorney, had seen sort of what happens when you don't allow people to expunge their records, and also how just rigid the expunction laws are, and already knew sort of the stories that we're trying to get to other individuals. And so with that strong support in the Senate, we decided to diverge substantially from our past experiences, where before we had gone to the DAs at the beginning and sort of negotiated, see sort of where they were willing to go. We decided not to do that and decided that we need to build up momentum and just basically try to truck them. But we knew we would, not completely be able to do that just based on, again, how powerful they are. But we did want to build up momentum and not just completely defer to district attorneys to carry the conversation. The other issue here is that we'd already negotiated where, for terms of subsequent prosecution, an expunction means before this legislation meant very little, and now it means absolutely nothing. That we're not trying to shield individuals from the subsequent prosecution or any sort of punishment. We're trying to give them a chance to get a job, and so there's a strong bifurcation there. But still, the DAs felt like they should be a central part of that conversation, even where you were just talking about the collateral civil consequences of the record. And then the other big thing was understanding the limits of technology. And what you see in the Second Chance Act is a reflection both of the political landscape, but also largely technology, where we do not have e-courts and sort of we're having to build on to a legacy system. And so it was important to understand where the actual limits of those were, because in my experience, when you're dealing with bureaucrats, especially in the AOC, they'll tell you something can't be done, and they're not lying, but they're just assuming 5 separate things. And so to get in the same room and push on those assumptions is essential in creating, sort of a creative way to do this. And I think a good example of that is with the automation that we did eventually have. That was based on the idea that in North Carolina, the actual expunction process is very staff heavy. I mean, it is the literal destruction of a physical file. And then the electronic database pulls it from the publicly available database and sends it to something that's only available to prosecutors. But that meant that just based on the old system, all we could do is automate the expunction, dismiss charges moving forward, where it's in their hand because it's coming directly from the court. So the shuck is in their hand. They can put it in the expunction destroy kit and then click a button and it takes it out of that database and sends it to the expunction database. But everything else, we sort of hit the wall with technology. But beyond that, there was also a lack of political will, I think, to go too far beyond that. And we'll talk more about the 2-stage campaign in a little bit. Next slide, please.
All right. Wait, can you guys hear me? I'm sorry, my internet went out, so please let me know if you can't hear me.
We can hear you.
And also, I apologize if anything I say is redundant, because I don't know what Daniel said because my internet went out. But I really wanted to talk a little bit about kind of our approach as to how we got here. So we talked a lot about the legal and the relationships with the decision makers. We'll talk a little bit more about communications as we talk about next steps, but also organizing and how important base building is and how important that work kind of played a major role in how we got here. So as Daniel mentioned, for the past 10 years, we have been kind of advocating for these second chance policies and having these second chance lobby days every other year. And, I remember back in law school, there maybe were 100 people at Second Chance Lobby Day, but in 2019, we had, organized year after year until we had 1,000 directly impacted people on the lawn of the legislature, kind of there, ready to tell their stories, ready to talk to the legislators about why the Second Chance Act is important and what collateral consequences mean, and to really just have those in-depth conversations with people who don't always know someone with this story and don't always understand what life can be like if you have a criminal record. And I think really what you see is that a lot of decision makers realize this person isn't very different from me. You know, this could have been me in any other situation. And so having that direct conversation, Hakim touched on it, so I don't even feel like I need to go further into it, really played a major role in how we got to where we are. Just imagine 1,000 people sitting on the lawn of the legislature in a black shirt with a big yellow button that says, "I'm for second chances." That is powerful. And the very next day after Second Chance Lobby Day in 2019, the Second Chance Act passed the Senate unanimously, not one vote against it. And so then things kind of got pushed off. And COVID happened, changed things a bit. We weren't able to go back and buses of people to the legislature. But I don't remember who mentioned it, but this is when many of the
We seem to have lost Whitley again. Daniel, could you step in, do you think?
Yeah, I will. So sorry, so I would have actually explained that slightly differently, but you know, we actually got it through the Senate unanimously, and then that's when the DAs took their stand, and we actually negotiated with them, lost the expansion to all. We tried to expand petition-based relief to all nonviolent felonies, and they took a stand and stopped us from doing that. And so it was all misdemeanors and up to one incident of nonviolent felony convictions. And actually, you know, got that through House Judiciary, House Finance, House Rules, and then just could not get it put on the calendar. And we're limited in sort of our tools by that point because of COVID and other things, and really had to rely on our sort of, I would say, our partners on the right, who were, I give a lot of credit to Americans for Prosperity, American Conservative Union. When we talk about it being unanimous, I'm sure it would have passed the Senate, but I know for a fact it's unanimous because I saw David Safayan go to a powerful Republican legislator and tell him to sit down and shut up, or he would be primaried if he continued to make exaggerated claims about how this would lead to the apocalypse. And so, and the good thing was that was a pretty isolated perspective, and so he was able to do that. But again, sort of the broad coalition was crucial. But you know, we did not get it over the finish line until after George Floyd's death and the protests in the streets. You know, and that was 13 months after it passed the Senate, 12 months after it already passed the House committees, and it just been sitting on a shelf. And honestly, I think the Speaker of the House, who didn't like the bill, was just backed into a corner and looking for something on a shelf. And so at that point, we had a decision to make: do we push for more, or do we sort of cash in the what we've done and then start again on the next bill? And so we did support passage of it. Next slide, please. But can't overstate sort of what it means to have that many people on the lawn of the legislature. With, you know, we do not try to make our shirts pretty. We try to make them, you know, clearly marked. And so, oh, Whitley, you're back. So just going through Second Chance Lobby Day. And then, yeah, if you want to wrap it up there, I think next steps is after this.
Thanks. I was trying to download the app on my phone to connect. I don't know what's going on with the internet. But Second Chance Lobby Day, we had 16 charter buses bring people in from regions across the state of North Carolina, so that we had impacted people from every region of the state of North Carolina to join us to have those conversations with legislators. I'm not sure exactly where I cut out, but really the storytelling component that Hakim was speaking of is extremely important. I don't think that we would have seen that unanimous support from the Senate the day after if we didn't have everyone, as you can see in this picture, out there in support of Second Chance Lobby Day. We had a press conference when we talk about communications, organizing, and legal advocacy. All of these things play a role together when we want to see the progress. And so since Second Chance Lobby Day, our Second Chance Alliance, which is our alliance of impacted people and organizers and advocates and congregations and supportive community members, the leadership of the Second Chance Alliance has begun to develop chapters in various locations across the state of North Carolina. I think we saw with Lobby Day, we were mobilizing people on an issue, but we really want to organize and develop this foundation and base build so that as we continue to have these opportunities for advocacy, and I don't even want to say bringing people into the fold, but really pulling from the people who are impacted in those chapters as to what we should be advocating for. Hakim talked about looking at legislation and being able to give feedback. What kind of legislation do you want to see? What is really going to help impacted people? And so really being able to grow those chapters and kind of foster the leadership development of impacted people in this fight is what we want to continue to do in North Carolina.
Thank you so much, Daniel and Whitley. That was not only very interesting, but it was a heroic attempt to conquer some technical issues. So Whitley already touched a little bit on next steps, but now we're going to talk about next steps, starting with Georgia. Brenda, if you could get us started.
Sure, I will try to be brief. So, yeah, I think I mentioned that SB 288 didn't take effect until this January because of the strange session that we had this last year. So we've been really focusing on education and getting the word out so that everybody that is eligible will know that they are eligible. And it sounds like the political climate in North Carolina is very similar to what we have going on here in terms of the power of, it's called the Prosecuting Attorneys Council here. And we, you know, they were like, don't bug us this year. We don't, you know, we have done enough. We don't want to come back. We don't want you coming back. And since it wound up going into effect in January, we were okay with that, other than some minor cleanup. But we've certainly made it known that we will be back to try to expand the remedy. In terms of what we're focusing on from a policy perspective, right, this year is probation reform, which is relevant for expungement for us because we have the longest probation sentences in the country, but on average 2 to 3 times longer than other states. So like for felonies, if you can't apply for a pardon until 5 years after you're off paper. So 5 years after you completed your probationary sentence. It's not unusual to get 10, 20, 30-year probation sentences, straight probation sentences for nonviolent felony offenses in Georgia. So we are really focusing on shortening those sentences and have a bill that's pending that would allow people to terminate their probation in most circumstances after 3 years, which is really going to be essential to shortening those time frames. We certainly need to get a better remedy for felonies. So, you know, you have to apply for a pardon. We need a remedy. I mean, an automatic remedy would be awesome, but we don't have a unified court system in Georgia, so we're still trying to figure out what that would look like. So at least to get a straight petition-based record clearing remedy for felonies that doesn't go through getting a pardon, because the State Board of Pardons and Paroles tends to be a pretty conservative agency and sort of contrary to what else is going on in the state, sort of leaning more conservative and making it more difficult for folks to get a pardon. So we would like to be able to bypass them, and hoping by inundating them with applications that at some point we can get them to support that idea as well. There are a couple of bills pending that would expand expungement and make it automatic from well-meaning lawmakers that don't necessarily understand the backbone of how our system works and what it takes to make something automatic. I think it's good to keep the conversation going, but we're probably a ways away from some automatic remedies in Georgia. On the next slide, just wanted to, I mentioned that we've been focusing on education. We used to think that the hard part was getting the law passed, but it is certainly, particularly when you're not automatic, it's getting it implemented. I mentioned the misdemeanor number. We've got 1.5 million people that could potentially clear their entire record under SB 288, not to mention all the folks that might be eligible to get a pardon and then get their felony off. We are the only organization in a very large state of 159 counties that is providing this service to people that can't afford an attorney. So we are trying to look for, funding, of course, for one, to expand that, but also creative ways to meet our service gap, recruiting some volunteers that aren't necessarily attorneys that might be able to help with pardons and get that process moving along for folks. We've been in conversation with some local prosecutors about expungement desks, kind of based on the model that most folks are probably familiar with out of Chicago and Cook County that Cabrini Green Legal Aid runs, where folks could, come into the courthouse and get some help in preparing some pro se materials to be able to apply on their own. And then we're also, in the absence of automatic, looking at ways that we might be able to utilize technology to do that, in at least helping folks to figure out whether or not they're eligible and generating the documents that they would need to apply in our petition-based system. But certainly it's a great problem to be able to have, but a daunting amount of work that we have in front of us to try to make sure folks can access this remedy.
Thank you, Brenda. Now, John, to talk about Michigan. John, you're muted.
Can you hear me?
Yep, there you go.
Great. Sorry about that. So we're putting together an implementation campaign right now for the Clean Slate laws that we passed. The petition-based expansions go into effect in April. So we're working on putting together a low-cost legal assistance network for people. There's a huge amount of interest, as you can imagine. And we're going to be doing a lot of outreach and public education, not just about the law going into effect in April, but really trying to get people understanding that the automatic is coming and they're going to need to be aware of it, because if a person does not know their record is sealed and they keep checking that box, it's not going to solve the problem. So we have a lot of work to do in terms of public education. There's some budget stuff we got to do to get some of the implementation done, and there's also some technical assistance we got to work on this year, but a lot of it's going to be the public facing outreach.
Absolutely. Some of the other things that we'll be doing, particularly in pushing directly impacted people's involvement at the next level, is we know we have to have a huge educational component involved. Clean slate or expungement, as it was before this new law, people just weren't applying. They weren't applying for it. We had roughly 90+% of people who were eligible were not applying for it. And that's similar as what Whitley mentioned in North Carolina. And because of that, we understood that if the new law was to expand it and include more people, then what type of toll would that really be on our state of people being eligible but not applying for expungement? And here we are, done all this work to get legislation passed to actually benefit and help people. And if it's not helping anyone, we've done all the work for nothing. So we've been fortunate that we established a relationship we built with our community over the last 2 years. But critically now, the law is passed, there is some options for us to do some education outreach with some funding. The Department of Labor and Economic Opportunity released $4 million to Michigan Works associations all over the state of Michigan. And what that will allow Michigan Works agencies to do, and we have a huge of them all over in our counties, all across the state, that will allow them to actually hire a navigator who will be responsible for the Clean Slate expungement process. That person will be also responsible for running the program at each Michigan Works site, allowing for the assistance and the support and the services to exist there on their site, where many people access employment opportunities already at Michigan Works. So it's a great opportunity for us to do some education. Here in our region of southeastern Michigan, we have a huge array of Michigan Works groups that are partnering together to make sure this happens. And so what we plan to do is, just like we used to run a lot of what we call clean slate clinics or expungement clinics, where people could come, find out about if they were eligible and actually get assistance walking through the process. We're going to continue that actually, so that people will be able to actually go to a site, a location in their county, and if they need the assistance, the full assistance with financial support, with walking through the process, they will be able to get that at our Michigan Works site. Also in Detroit, we have a huge program there, Project Clean Slate. They've been in the forefront for many years doing the Clean Slate work. They will continue to do a lot of the massive education work in and around the Detroit area, where our largest group of people with criminal histories are located at. The last thing that we would do with the legal resources that are available at our Michigan Works, the partnership which is critical, is with our legal aid associations all around our state, right? And here in Jackson, Ingham County, and Hillsdale County, our legal aid associations are really pretty much rooted right in our Michigan Works Association for this project. And they're going to be there providing on-site legal assistance, because it's a huge maze to understand who's eligible, when is the person eligible, how does the person proceed with filing for expungement. The legal assistance is going to be critical to doing that. And so we're fortunate that we have some partnerships here in the state of Michigan, and we hope that this partnership will be as expansive actually as our actual bill.
Thank you, Hakim and John. Now to talk about North Carolina, Whitley.
Absolutely. I've heard a lot of the same things, really thinking about implementation of what we have seen happen thus far. And first, just to talk about the DA initiated relief that we discussed. So our administrative office of the courts has provided data for the counties where the district attorney has agreed to begin this process. And so far in North Carolina, the last update I got, that there were 30 district attorneys that had reached out about the data for these raised age expungements. So far, I believe 2 have kind of gone forward with generating some petitions and some test batches. And so we as a coalition and as partners are continuing to provide relevant support, thinking about how we can, chop up the data more so that these things can happen more quickly. But as many people were discussing, this notice and education is the most important. It's why we can't just think about the legal aspect of things. We have to think about organizing. We have to think about communications. So in this slide, you'll see one of the many billboards that we had up across the state of North Carolina. We had them in each of the counties where we were launching Second Chance Alliance chapters, as well as kind of looking at the data of places across North Carolina where you had the highest populations of people with felony convictions based on a data set that we got, really trying to target those areas with the billboard so that we can make sure that people who may be impacted by these law changes are seeing this and can be redirected to our website so that we can provide the relevant information that we need. In addition to the billboards, we had radio ads redirecting people to that website as well so that folks know what's happening, so that they know how they may be impacted. There is a flyer, a handout that is provided in the materials today that's a one-pager front and back that really just lays out what the changes are in the law. And we had our organizers across the state, again, passing these out at barbershops, in corner stores, places where people just frequently go, even in the pandemic. You have to go to the grocery store, and just kind of posting up and having this information for people with our contact information to be able to answer those questions in order to get the word out. Our organizers within the Second Chance Alliance have regular monthly chapter meetings. And I know that myself, Daniel, other lawyers in our coalition have attended those virtual meetings to talk about the Second Chance Act, to talk about the changes in the law and how people may be impacted by it. And so we're also working to improve our Second Chance Alliance website so that there's only so many of us to be able to answer the phone and these emails and these questions, so that we can make sure as much information is publicly available on the website as people may need. So, who is eligible? If you are eligible, what form do you need? How do you fill out this form? What additional materials might you need? And so we're working on getting that together so that it is more comprehensive and people's questions may be answered there. Also just kind of working in collaboration with our North Carolina Equal Access to Justice Commission, who has a fair chance site up where people will be able to go and see if they've been impacted by some of the mass relief efforts that we've been talking about. And kind of working with some of the Code the Dream folks to see about pre-filled petitions. I'm not sure if you guys are familiar with like a TurboTax type program where you answer relevant questions and then a form is created for you, and you don't have to go in and figure out, well, what does the court mean by this? And am I supposed to fill out this field? But all of it would be pre-filled out. You could print it out and take it to court with you. So we're trying to see if we are able to get that implemented and put it on multiple sites that we know impacted people may use and could use as a resource. And so that's really about implementation. But as it comes to new legislation, we're talking about expanding eligibility. And Daniel's going to talk a little bit further about the technology and kind of where we are with that and kind of next steps. But we're currently trying to expand eligibility. I know that, I think it was John, or maybe it was Brenda, that said the prosecutors always say, don't come back, but we keep going back. That is not going to stop us. We will continue to come back as long as there's more relief out here available for the people in our communities. And so our goals right now are really expanding to multiple felony convictions. I think John mentioned that's happening in April in Michigan. Kudos to you guys. Hoping that we can follow in your footsteps, maybe more than 2, we'll see. But we're also looking at drug distribution felonies. In North Carolina, we pride ourselves in saying non-violent felony convictions. Possession with intent to sell or distribute cocaine is not violent in nature, but it is excluded from our expungement eligibility. So really trying to work with people who are impacted for storytelling reasons, working with data analysts to kind of look at the data to show how common you see these convictions coming up for people in North Carolina, so that hopefully we can advocate for further change and more folks that have drug convictions are able to get those expunged. We're also thinking about breaking and entering. That's the most popular, or not popular, the most commonly, when you look at the data for all the felony convictions in North Carolina since 1986, it comes up more than any other conviction, and really taking that data into consideration in our advocacy. And then one last thing that we're kind of looking into right now is not allowing disqualifying convictions to bar you from expunging something that you are qualified to expunge. So, you may be able to expunge larceny, but you may not be able to expunge robbery. But just because you have that robbery, that larceny shouldn't be barred from coming off of your record, if that makes sense. And so I think I will pass it to Daniel now to talk a little bit more about our next steps as it relates to technology and automation.
Thank you. Yeah, the big effort in stage 1 was to basically take away any sort of procedural barriers that would eventually lead to problems with automation. And so that's anytime you have to turn in affidavits, as John was saying, the criminal justice debt, we sort of pulled that out and made it just where you owe restitution. And so, really setting it up in every way to basically both make the sort of process easier for petitioners, but also with the idea of removing, just getting rid of stuff that would be cited later as a barrier to automation. And so now that we're in, we basically achieved stage 1, and we're in stage 2, what we're relying on is a report that's coming out in October that was mandated by the Second Chance Act that says, the Department of Public Safety, the Department of Justice, and the Administrative Office of Courts has to come up with a process by which the entire system could be automated, because that's what we're running into. The problems with automation is the communication between the systems, and even if we sort of, the e-court system is coming online in North Carolina over the next 2 to 5 years, and so we are definitely focused on making sure that the capacity is built in there so that everything could be automated if that's where the public policy goes, because I think legislators were very frustrated that so much of the public policy conversation was limited by the technology. And so trying to avoid that as this e-court system is being built, but again, also understanding automation between the different agencies is, I haven't really seen, as far as I'm aware, any state sort of master that, and I'm actually curious to ask y'all some questions about that. But understanding sort of how that would work, but also while preserving the efficacy of an expunction. And I think that's what we're battling now, is as we sort of automate things or make expunctions more accessible, a lot of times you have to give up the value of the expunction and the efficacy of it, which databases it pulls from or deletes. And so that's really the balance we're trying to achieve right now. But I think we have a good chance of doing that.
All right.
That is, yeah, thank you.
Thanks, everybody. That was just so much information, very, very inspiring stuff. So if it's okay with the panel, I would love to just kind of ask a few questions in this section. I think it would be really, as we all know, 2020 was a crazy year. Not only did we have a pandemic that affected our legislature's ability to meet, we had, of course, budget issues, a recession. We also had, a hugely eventful summer. We had the murder of George Floyd and the protests that came after that. And I'm really wondering if, our panelists can talk to how those current events affected their campaigns, how it affected these laws getting passed, how it affected the community and the organizing. So I wonder if we could start with Georgia, if you have any thoughts on that, Marilynn or Brenda.
Well, I would say that it most certainly had an effect on our campaigns. They slowed down, but they didn't really stop. The pandemic was more of a more, I'll say what I want to say, the pandemic did more of stopping the campaigns than the uprising actually, and the pandemic actually in a way kind of enhanced the campaigns, because people began to listen and see what, you know, what we were going through and what was happening in the world. Whereas before they were pushing back, but it in a way, people, legislators, lawmakers, they got more involved in the community to see how they could support in a lot of ways. And it was crazy because I actually felt like that everything we was doing was just doomed at this point, but it didn't happen that way. It kind of like put a spin on it and actually gave us more opportunities to be in the room, not in the room, but on Zoom and virtual meetings with more elected officials and lawmakers than what we would have been in person. The people that we couldn't meet in person, we were able to get them on Zoom. We were able to get them on the phone. We was able to make more contact. And it made more sense that people were more engaged, because we all now coming together, because we didn't know what was going to happen, not just to us, people that are impacted by the system, but those that was not impacted by the system.
Thank you, Marilynn.
Mhm.
Maybe if I could hear from the folks in Michigan, did you find the same thing, Hakim or John?
Go first, Hakim.
Well, for us, much of the bulk of the work that we had done preceded COVID, and actually our bills were kind of sitting in limbo, waiting for resolution, waiting for votes to be handed down in the Senate. And so what ended up happening for us was that we were in kind of limbo, waiting that process to see would the bills continue to go forward during COVID, and fortunately they did. And I want to say, like Marilynn, perhaps, I'm not sure to what extent the summer's uprisings and protests could have contributed. I'm not sure. It doesn't seem, it don't appear to me at face value that it had a direct impact. I think more so the impact was that there was momentum going into COVID, and our governor had recently launched a task force, a criminal justice task force on pretrial detainee detention, and that really, at the onset of the heels of our work, that task force kind of kicked in its work, and it was supported by bipartisanship in the legislature, and it kind of just took a toll and took a ride, a wave that allowed all of the criminal justice bills to just soar right on through in 2020, and it was wonderful, and we were very excited.
Yeah, it was kind of a confluence of events, you know, in 2020 that it kind of felt like right place, right time in some ways, just to push this policy over the top. I mean, I think in some ways it was, you know, it's a feel good policy, and it was something that people could really feel good about working on during such difficult and divided times. And you know, I really thought people, you know, when faced with the challenges of the pandemic and all the unrest around, you know, George Floyd's murder, I think people really felt like this is something they wanted to do, and they saw the need to really make 2020 about criminal justice reform in Michigan. So, you know, we can't take responsibility for a lot of that, but we, as Hakim said, we did have really strong momentum behind the bills sort of going into the spring, and that helped keep us going.
Thanks, John and Hakim. How about North Carolina folks?
I think we can probably echo a bit of what other folks have said about the unfortunate murders of George Floyd, Breonna Taylor, at the beginning of the summer. That mass mobilization of people on the issues of criminal justice reform. You know, our bill was introduced in the House for a full vote right after this happened, right after these task force were developed. And so we can't help to think that there was some correlation there. That wasn't our work, but when it relates to the COVID-19 pandemic and how that impacted our organizing efforts, I mean, we had to make a full, you know, 360 and figure out what we were doing. At the end of 2019 is when we started to talk about our chapter launches across the state, and I believe we had 2 of them before the pandemic hit. And how do you have a chapter launch when everyone's at home? and thinking about many of the people that we want to get to these chapter launches and to get involved may not have access to Zoom or may not have access to internet and to be able to participate in these virtual activities. Most of our launches, we'd have food and we'd have activities for the kids and we'd have speakers and it'd be outside and it would be a grand event to bring people in and start talking about these issues. It's really hard to do that over the computer and to kind of gain that interest, garner that interest to bring people in. So we had to get creative. We had to get creative about how we were going to pull people together. We can't go out and, we would, door knocking is a tactic of organizers. You think about a lot of the in-community work that we're doing. Hakim talked about listening sessions, and that's something that we like to do. And none of these things were possible given the state of things. So we had to get creative. We had to be resilient. We had to be innovative. We really used phone banking as something that our organizers were able to do during this time. We had phone banking parties every Saturday talking about these second chance issues and trying to garner support for this. We started hustle texting, mass text messaging to folks to inform them of what's going on and what changes we're seeing in the state. And so those tactics will continue to be used along with our in-person tactics as the country continues to reopen and we see the changes as COVID hopefully goes away.
All right, thank you. We have a question from a member of the audience about your thoughts on this movement that's happening across the country where people are agreeing to expunge cannabis-related charges, and they're making a distinction between cannabis-related charges and everything else, like they're doing automatic expungement of cannabis, but nothing else. What are your thoughts on that? Is that a good thing or a bad thing? Does it help you or hurt you? We can start with Michigan.
So for us, it hasn't hurt us because it's all sort of happening at the same time for us. I do think, there are potential downsides just to going for the low-hanging fruit when you're talking about automation. We really leaned in on the automation. We said, look, we've got 2 million conviction records in our state. We're not going to solve the problem through the petition process. It's just not scalable. We either automate this or we throw up our hands and give up. And I think that really got legislators and our champions in the executive branch bought in on the concept of automation. And then it wasn't limited just to cannabis or, the lowest level misdemeanors. It was saying, okay, how far can we take the automation given the current political environment? And, let's come back and do what we can later when the environment's better.
Any other thoughts from Georgia or North Carolina?
Well, we haven't made any progress on cannabis reform, so that hasn't really been part of the conversation here. But I would say I'm always reluctant of sort of, picking out individual convictions and, as something that's palatable to everybody and try to keep the conversation as broad as possible. In our state, as I'm sure in all the others, there's a lot of prosecutors and legislators that say we want to help people who were convicted of non-violent crimes, and the definition of violence is very, very, very broad, and I don't think they fully understand just what conduct can be charged as a violent crime. So I feel like as a strategy, not trying to pick that out might be better for us going forward.
All right, we have another audience question about pushback from the police. Has anybody experienced pushback from the police, in particular them trying to find loopholes in the laws and trying to figure out ways that they don't need to expunge their own records? Anyone who has any input on that? Has anyone experienced that in their states?
I think there was a measure of pushback from law enforcement. We did have some law enforcement come and testify against our bill, but we also fortunately had some testimony at our Senate hearings or our House hearings in support of the bill packages from a law enforcement association. I don't recall the organization right now. But we did have that competing competition there. Our prosecutor association, they weighed in, and from a point of view of directly impacted people, prosecutor associations are essentially a wing of the law enforcement to us. They're extension of police officers. They just happen to be prosecuting the cases. And so I wouldn't say that we had any substantial pushback from law enforcement to the extent that the question really asked. I wouldn't say that anything came out publicly or anything like that. We did have pushback, and I don't think that the pushback we really experienced was strong enough and bold enough from anybody to really stop this bill from moving forward.
All right, thank you. Any other thoughts on that? Go ahead, Whitley, sorry.
I was just going to come in and say that when you get pushback from law enforcement or whatever the decision maker is, I think part of the best strategy is to think about, you know, what framework are they looking at? From what framework are they looking at this? What is the lens that they bring to the table? And law enforcement is thinking about people committing crimes on the streets, and they're going to have to arrest them. So looking at recidivism and showing how second chances and expungements actually help prevent recidivism is kind of the argument that I think is helpful to bring to the table and in those discussions with law enforcement as we're trying to get them more kind of on the same page.
Yeah, that's a great point. And it reminds me of a couple things I should mention. First, there was really great research on record sealing that came out around the time we started our campaign from the University of Michigan. It was I think a 10-year study on economic outcomes from people who got expungements in Michigan. And you know, the recidivism rates were, you know, below the general public. People saw a 23% increase in income in the first year after they got their record sealed. It's just the empirical case to do this was just overwhelming to people. And that was really helpful to us in dealing with some law enforcement pushback, because they tend to come in and say, hey, I'm concerned this is going to impact public safety. And it's like, all right, well, how? Because we got the data. And, you know, that was one of the things I think that made this campaign different for us than some of the other ones we've been involved with, because we really did have, I think, a compelling empirical case that this should be done, and not just done on a smaller scale through petitions, but in a comprehensive way through automation.
Thanks, John. I'm just going to take an opportunity to plug our next webinar, because you plugged it for us. We're going to be hearing from two researchers about research that they've done about the impact of expungement, including the research from Michigan that John is talking about that he used in his legislative campaign. So that's on March 26th, if I'm getting that date right. It's a Friday. So you'll be seeing emails about that. Please come to that webinar. I think Daniel has a question for the panel.
Yeah, I don't want to pass up the opportunity to ask y'all this since I have you in front of me, but you know, one of the issues that we're dealing with is how you balance you know, the mass expunctions and the automated expunctions, and really expunction in general, but it just becomes more of an issue with mass and automated, with the potential immigration consequences. And so, you know, what we've been dealing with in North Carolina is the issue of that, you know, a lot of times immigration is not federal immigration is not looking at the criminal record necessarily. They want to understand the underlying behavior. And so if there's a flag there, you know, that says there was some sort of incident, but the record's been expunged, you know, that can actually lead to a real problem of somebody, you know, just being able to show, no, it wasn't that case, it doesn't apply. Partners have been reluctant to basically, you know, not pursue automated or mass relief and pull records away from the state that are having harsh consequences in people's lives, in response to sort of that same thing happening in the immigration field, where these records are being used and held against people for years. And so, but on a very sort of individual level, it could be very consequential. And so how are states balancing that to actually allow individuals maybe to get copies of their own expunction orders where the system has been automated or there's mass relief?
Yeah, so we looked at a couple different issues related to that. I mean, I think part of the answer is just that Michigan's not set up as badly when it comes to federal data as some other states. We control our own data as part of the interstate compact around that. And we added some language to allow people to, the court to retain jurisdiction on the record if someone needs to go back and get it. They were already permitted to do that, to receive a copy of an expunged record under our existing statute, so that wasn't an issue we ran into. But we did get some input from immigration lawyers as we were looking at drafting.
All right. Well, Thank you guys so much. We have already gone a little bit over time, but everyone did a wonderful job at keeping themselves succinct. I would just like to congratulate everybody on that. We filled this hour and 20 minutes with a lot of information. I'm wondering if anybody on the panel wants to do a last 1-minute takeaway, things that, you know, the biggest lessons learned, starting maybe with Georgia. Do you have any biggest lessons learned that we should end on?
Well, I don't know what my biggest lesson learned is, but as I sit here talking to you guys, I think there's a real need to coordinate, particularly around technology. And, you know, Whitley talking about the TurboTax petitions and stuff. Like, there's a real opportunity, I think, for us to collaborate and, you know what each state is doing, and, you know, try to use some of that technology to stretch across multiple states. So I think for implementation, you know, I think we tend to coordinate a lot around the policy, but would like to see us coordinate more around implementation, you know, learning from other states about how to do that. So I'm going to be emailing you guys for sure.
Wonderful. Michigan? Oh, John, you're muted.
Sorry, you think I haven't been doing these all year? It's like a couple things. So I think having really strong inside-outside components to the campaign was important. We had really strong business support in addition to really strong grassroots support, and I think that's critical. We also had really strong support within the administration, the legislature. You know, get the bureaucratic establishment in line, overcome their objections, whether that be cost or feasibility. And then we really thought it was a really great example of how criminal justice reform can be messaged to conservatives, particularly around jobs, around public safety, and around getting government out of people's way. You know, ultimately, it's the government's choice to keep these records public. Maybe they shouldn't do that. And I think that turned some of the conservative opponents to this policy around a little bit and got them thinking about it differently. Because, you know, we do in Michigan have Republican-controlled legislature. I don't know if I mentioned that.
Thanks. North Carolina? Whitley?
I'll chime in. I would just say that Hakim really just re-emphasized the importance of education and leadership of directly impacted people. That was one of the greatest strengths of our campaign here, and it sounds like it was the same there. I think resilience is really important. You're going to get turned down. You're going to have to go back and forth with drafts of bills, and just being ready to stay the course and continue on. And relationship building. We talk about directly impacted people and communities, but also with decision makers. We have a bipartisan coalition of advocates, and making sure to kind of develop and foster and maintain those relationships is important as we keep going back for more. And then finally, just building people power. So after you have educated and fostered the leadership of directly impacted people, really kind of base building, because most of these decision makers, when we talk about prosecutors, when we talk about sheriffs, when we talk about legislators, these are all elected officials. And so by building people power, when folks aren't doing what needs to happen for our communities, we can vote them out. So those are my takeaways.
Thank you all so much. This was such an inspiring panel, an informative panel. I just want to thank you all for your time and for being here. And I will be sending out an email, as I said, about our next upcoming webinar on March 26th about research, expungement research, and how to use it. So with that, I will sign off, and I hope everyone enjoyed it. Bye.
All right, bye.